Supreme Court of India dismissed the appeals by Union of India and stated that detailed analysis of the relevant provisions of the Finance Act 1994 and amendments made thereto in light of clauses of agreements highlighted during the course of submissions as well as judgments of this court would not persuade Supreme Court to take a different view than what Sikkim High Court has taken in the batch of cases of Future Gaming Solutions Private Limited and Summit Online Trade Solutions Private Limited, holding that lottery distributors are not obligated to pay service tax to the union government, delivering a victory for Future Gaming, India's largest donor through electoral bonds. A bench comprising Justice B.V. Nagaratna and N.K. Singh upheld the Sikkim High Court judgment, ruling that attempt to impose service tax on lottery operations was unconstitutional. Centre had introduced the tax through a Finance Act amendment. The Parliament introduced service tax through the Finance Act 1994 under Chapter 5, which took effect on 1st of July 1994, later through the Finance Act 2003. The Finance Act 1994 was amended to include a new category of taxable services, namely business auxiliary service, under subsection 19 of section 65, effective from 1st July 2003. Pursuant to this amendment, the Service Tax Department issued several notices to the respondent-assessees herein under the amended Finance Act in 2007, requiring them to register under the said Act for payment of service tax. The High Court had noted that betting and gambling itself is an activity, though the lottery ticket is a tangible thing that carries with it right to participate in the game of chance. Thus, all activities, right from the publishing of lottery tickets to the participation in the game of chance, declaration of draw, and even distribution of prizes to the winner, fall under the purview of expression, betting, and gambling. Thus, the power to levy tax on the organization, promotion, and marketing of lottery, being an act of betting and gambling, comes within the exclusive domain of Entry 62, List 2 of the 7th Schedule of the Constitution. The High Court applied the test of the principle of pith and substance and observed that the power to levy tax on lotteries, which are considered games of chance and fall under betting and gambling in Entry 62, List 2, lies exclusively with the state legislature. Consequently, Parliament's authority to impose such a tax under its residuary power in Entry 97, List 1, read with Article 248 of the Constitution, is excluded. The High Court held that while Parliament is competent to levy service tax under Entry 97, List 1, this does not imply that it can impose such a tax on lotteries, as the power to levy taxes on this subject has been conferred on the state legislature in List 2, that the residuary powers of the Parliament can only be exercised when no entry in any of the lists provide a legislative field. Hence, it is the exclusive legislative domain of the state legislature to levy tax of any nature on lotteries by virtue of Entry 62, List 2E. The High Court further held that when a distributor purchases goods at a commercial price, they are not acting as an agent of the manufacturer. Upon perusal of various clauses in the agreement, the High Court observed that the state government appoints stockists or distributors to sell the tickets to ultimate buyers, who purchase them at the MRP. These intermediaries must be provided discounts from the MRP to cover their expenses and ensure a profit margin. The High Court also said that the advertisement expenses incurred for promoting the state lottery are borne by the respondents' assessees herein to promote their own business, not as a service to the state government. Article 26 of the Constitution of India pertains to the division of subjects between the Parliament and state legislatures in the form of three lists in the 7th schedule of the Constitution, namely List 1 Union List, List 2 State List, and List 3 Concurrent List. Article 248 deals with the residuary power of legislatures. It may be mentioned that the residuary power is reserved to the Parliament to legislate on any subject, provided such power is not included in either the concurrent list or the state list. The Finance Act 1994 was enacted by Parliament in terms of Article 248 of the Constitution of India, read with Entry 97, List 1, which reads as under: any other matter not enumerated in list 2 or list 3, including any text not mentioned in either of those lists. It is also pertinent to mention that entry 92C list 1, which deals with taxes on service, was inserted by Constitution 88th Amendment Act 2003, but was not notified and was omitted by the Constitution 101st Amendment Act 2016 with effect from 16 September 2016. In these circumstances, Supreme Court observed that the Finance Act 1994 is relatable to Entry 97 List 1. Subsequently, by the same Constitution 101st Amendment Act, Article 246A was inserted as a special provision with respect to goods and services tax. For the sake of completion, Supreme Court also mentioned that it would be relevant to refer to entries 33 and 34 List 2 entries. These entries are the regulatory entries which read as under: theatres and dramatic performances, cinemas subject to provisions of entry 60 of list 1, sports, entertainments and amusements. Entry 62 list 2, as it stood then, dealt with taxes on luxuries, including taxes on entertainment, amusement, betting, and gambling, etc. According to this Supreme Court, if a central act is challenged as being beyond the legislative competence of the Parliament, it is enough to inquire if it is a law with respect to matters or taxes enumerated in list 2. If it is not, no further question arises. Thus, the wide words of substantive articles like Article 248 should be given full effect, and they cannot be cut down by the wording in the list in the Schedule 7 merely because certain known taxes have not been included therein. By way of Finance Act 2015, Clause A of the explanation to Section 67 containing the definition consideration was amended to include inter alia any amount retained by the lottery distributed or selling agent from gross sale of lottery tickets in addition to the fee or commission, or as the case may be the discount received, the difference in the face value of the lottery ticket and the price at which the distributor or selling agent gets that ticket. The said amendment would have no consequence and bearing on the substantive provision. This is because the distributor buys at a wholesale price from the state government and sells it at a higher price to the retailer. Recently, this court in K. Arumugam observed that conducting a lottery, which is a game of chance, is an activity conducted by the state and not a service being rendered by the state, which would enable the engaging of agents such as respondent-assessees herein for the purpose of rendering of such a service. That the assessees who buy the lottery tickets on outright sale basis have the burden of selecting them through the stockists for a profit as their business activity. The differential in the price paid to the state for the lottery tickets that are made available to assessee to sell and the price of the profit of the assessee. Thus, there is no promotion of business of the state which conducts lotteries as an agent. Consequently, there is no principal agent relationship. Rather, it is one of principal to principal. The conclusions in K. Arumugam are opposite to these cases also. Court also held that merely because the online agreement uses the expression marketing agent, it would not imply that respondent assessee is an agent within the meaning of expression under the provisions of Contract Act dealing with the agency. Hence, on a consideration of the agreements for the sale of online lottery tickets in juxtaposition with the agreement of the sale of paper lotteries, Supreme Court found that there is great similarity in the clauses of the agreement, and hence agreement concerning sale of online lottery tickets also is one between principal and principal and not between principal and agent.